Now, if you're watching this, chances are you or someone you know works at the World Bank, the IMF, or another international organization here in DC. If I lose my job, do we all have to pack up tomorrow? Welcome everyone to our episode today in Wait One U.S. Immigration Minute. Today I'm going to talk to you about the G-4 visa challenges for families. Let me start with a story. I had a client whose daughter was 17. She had lived in the U.S. for 7 years and this was her home. She was eligible to apply for permanent residency. But here was the problem. She couldn't get her passport. She couldn't get her birth certificate either, and her home country was too dangerous. The embassy here in the United States was not helpful either. Okay, so what did we do? We looked deeper and we realized if she cannot get her passport, if it's too dangerous, then she may be qualified for an asylum claim. We looked into the country conditions. We looked at objective and subjective evidence, which is required. And ultimately, we were able to protect her future here in the United States by filing for asylum. Why am I sharing this? Because if you're on a G-4 visa, you need to know this. The Department of State is only focused on the principal employee, not the children, not the spouse, which means families need their own immigration strategy, sometimes even their own separate legal counsel, which we'll talk about. Now, if you're watching this, chances are you or someone you know works at the World Bank, the IMF, or another international organization here in DC or New York, where I have been practicing for over 28 years. You've probably heard the term G-4 status so many times it feels like second nature. But what keeps you up at night aren't the acronyms. It's the questions no one at HR or Human Resources or the Department of State at times cannot answer for you, like what happens if my child turns 21? If I lose my job, do we all have to pack up tomorrow? When does my visa get renewed? Not my spouse's. And what forms do I need? And especially when it comes to unique forms I-56 and I-508, which are just in respect to anyone with diplomatic immunity. So we'll discuss that. I've been practicing for almost 3 decades, and I can tell you these are not technical questions. These are family questions. These are questions about whether your child can go to college, whether your spouse can, you and your spouse can stay together in the U.S., and whether your family's life has stability in America. So let's first dive in to one of the most common fears that I see and concerns is children aging out. Imagine this, your child has been here since they were 5 or 6. They speak English better than the language of their home country. Their friends are here. Their future is here. And then you realize when they are ready to turn 21, they're no longer considered a G-4 dependent. Overnight, their status can evaporate. Now, here's where families get tripped up. Sometimes the Department of State will continue to renew a dependent's child's G-4 visa even after they've technically aged out. So parents breathe a sigh of relief thinking we're fine, but the law doesn't see it that way. That renewal doesn't reset the aging out clock. And when you go to file something with USCIS, they may say your child has been out of status for years. And if your child is out of status for years, there's serious consequences that come that are bars that could be either 10 years, 3 years, or even permanent. That's why timing is everything. If your child is 17, there may be opportunities to apply for permanent residency, but only before they turn 18. After that, the options narrow very quickly, okay? So for college-bound kids, switching to an F1 student visa can buy breathing room, and in certain cases, like my client's daughter, asylum may even be a path. You don't want to miss those important cues or important reliefs because you don't have counsel specialized in your family as a G-4. But the key point is that we don't wait and we don't rely on the expiration date on the I-94. What matters is the birthday for your children and not the paperwork, okay? So let's talk about a different topic that also is feared, but I'm going to dispel that fear hopefully here, is losing your job as the principal G4. When you're losing a job at an international organization, some contracts, we recently had a client whose contract was federally funded, and with all of the reorganization right now under the new administration, she did lose her G4 position. However, despite the stress, we were able to help her. When you add the immigration consequences, it just seems overwhelming. So the client called me and she was really distressed, and the termination, it didn't mean that she had to leave immediately. Within 30 days, we offered to bridge her status, or in her case, she was actually engaged for years, and they ended up getting married, her and her fiance. And he went ahead and he did file for her, and she did have to do a form I-508 to relinquish any G4 privileges and responsibilities, is what the I-508 is for. All right, so the G4, they are facing unprecedented at this time. Their jobs are being, what I guess we could call it, they're being laid off, or they're being reorganized, and sometimes G4 people want to know if they can also willingly leave the job. I don't discuss that here, but you can contact us at the information provided below if you're looking at a reorganization in a G4 and you want to consider other options, okay? So at the end, the takeaway is losing your job doesn't mean you have to lose everything, but the sooner you speak and get legal advice, the sooner the doors will stay open. So the forms can be a maze, as everybody has seen, and with G4 they require a couple different forms, and those primarily are the I-508 and the I-566. The I-508 applies a lot to areas where you are looking as a G4 employee to go into a status of permanent visa, so that would be your green card, versus an I-566, which has to be filed if you're looking to move into another status, your change of status for either your dependents or yourself. So again, these forms, you should definitely go ahead and look at them with an attorney to make sure which applies and the information is filled out correctly. And families often go wrong because they'll depend on human resources or HR departments, because they sound like they really know what they're doing, but that's not their job at the end of the day. And if anything goes wrong, they're not held liable like attorneys, okay? So your HR department, they'll guide you or they'll guess. And when they guess wrong, you lose time, and sometimes you lose your status altogether. So don't guess, treat these forms seriously, and don't be afraid to get outside counsel. Even many immigration lawyers don't regularly handle G4, so make sure you're asking a lawyer to have they handled the G4 cases, and make sure that you have that some type of record or verification about the G4 handling, which is a unique visa, which in the Washington, D.C. here, we do have unique type of visas for various individuals from all over the world, ambassadors, etc. So renewals are something that don't always cover everyone, all right? The principal employee who gets renewed, all right, so the G4 employee, when they get renewed, everyone breathes easily. But the child or spouse, once again, we have to talk about how does the renewal occur for them. Sometimes there is a delay for the child and the spouse. It's really important to seek counsel at that moment of delay, because it could be either a technical issue, it can even cause children to age out, and basically you want to make sure at all stages that you're going to be covered, and the sooner you get your own legal counsel, the better. I always advise families that each person's case is unique. Separate attorneys are often needed for derivative dependent family members, because different regulations apply, which can't be missed depending on the situation. Let's talk about permanent residency. Yes, in some cases it's possible, as I mentioned. So retired G4 officers, spouses, and certain children can qualify under this narrow rule, but there's a catch. There's very strict filing deadlines, residence requirements, and visa backlogs can easily push kids out of eligibility before a green card ever becomes available. So the underlying form has to be locked in, called an I-360. However, I really, at this point, we're talking about so many forms, I-508, I-566. Now I'm introducing I-360. I think it's clear you need to consult with an immigration lawyer before taking any steps as a G-4 into this world of permanent residency or change of status. And that's another reason why waiting until you're close to retirement or until your child is 21, waiting close to then is usually not acceptable. Okay, planning is needed, and with good planning and meeting with your own legal counsel early, say a couple years in advance, or from the time you decide you would like to either stay in the U.S. temporarily or permanently, a consultation with a lawyer is going to cost you way less than missing all the steps that you can do and plan and be well prepared to advance from G4 into your next status stage, such as a permanent resident or such as your student or your child going into F1 student status. So planning is always key, even here, okay? This is my final kind of takeaway that I want to mention. And again, you are going to have our information below. If there's any questions or comments, you can feel free to go and let me know. The G4 status can feel like standing on shifting sand. The rules change, the paperwork is confusing, and families often don't realize until it's too late that dependents are treated separately from the principal employee. But you don't have to go through it alone. Here's what you can do today. Collect and save every document. Your lawyers will need this as well. I-94s are available online. Any human resource letters about separation need to be very clear, okay, and visa notices. Track birthdays for your children and renewal dates for your visa. Track it like a hawk. Ask questions early. Don't assume HR or Department of State attorneys know the whole picture, nor are they required to know the whole picture. They're only focused on the G4 principle and the renewal. No nuances really outside of that. And most importantly, get independent immigration counsel for your family, someone who has walked this road before, who can help with family derivative beneficiaries, okay? And we've been practicing for nearly 30 years. We've helped many, I know 100 or more, at least. I've lost count of G4 families who we protect their futures here in the United States. If this message resonates with you, you can reach out to us, okay? If you have any immediate things, we have specific instructions below on how you reach out to our firm. Because of confidentiality, we want you to either email us at info@becapitallaw.com, and that is noted below for the spelling, or you can text us for fastest response from a lawyer at 703-966-0907. Also, we have links below that you can request an initial 15-minute meeting with myself or one of our other experienced lawyers. And remember, with the right planning and support, you don't have to live kind of in concerns or really nervous about the future of your family when you come in a diplomatic status such as the G4. The what ifs we can eliminate, and we're looking forward to assisting you. You can build a stable future for you and your family. Thank you for listening. Take care.